Thank you, ladies and gentlemen. My name is Professor Richard Hall. I'm Deputy Dean, Leadership and Executive Education for the Monash Business School, and it's my great pleasure to welcome you to tonight's very special public lecture featuring Professor John Ruggie. In addition to welcome you all this evening, I would also like to acknowledge the people of the Kulin Nations on whose land we meet today, and I would like to pay my respects to their elders past and present. I would also, if I could, like to thank our hosts this evening, the Global Compact Network Australia, and in particular, if I could also especially recognise the Executive Director, Kylie Porter, and congratulate Kylie, you and your team, for pulling together the inaugural flagship conference today and tomorrow, Rebuilding Trust in Corporate Australia, business as an agent of sustainable change. And can I say how much I appreciate the two sides to that sword, recognising both also the need to rebuild trust, but also the contribution that corporate Australia can make to sustainable change. I'd also like to acknowledge the sponsors, if I could, which is a little selfish, because the sponsors are very much Monash University. And first of all, in particular, if I could mention the Castan Centre for Human Rights Law from the Monash Law School, and of course, Monash Business School, who I represent this evening. I think it is absolutely critical that Monash University, and indeed Monash Business School, supports events such as these, and in particular is actively engaged in the promotion of the discourses and the debates and the agendas that are advocating human rights, but also labour rights and sustainability and anti-corruption and indeed pursuit of the Sustainable Development Goals. And of course, in addition to that, promoting the role of business in doing something active towards the achievement of those agendas. It is, after all, the mission of the Monash Business School to engage in the highest quality research and education to have a positive impact on a changing world. We are committed to developing our students as responsible global citizens, to working with our companies, all of our stakeholders and organisations that we work with to promote human rights and sustainability in their own organisations, across the supply chains in which they're implicated, in the markets in which they work, and in the societies and economies in which they exist. We are committed as a business school to the 17 SDGs. We are subscribers to the GRLI, the Globally Responsible Leadership Initiative. We are subscribers as well to PRME, the Principles of Responsible Management Education, and we're part of the Global Business School Network. Our values are human rights, social justice, and respect for diversity. It is very appropriate that we join with the Castan Centre tonight in sponsoring this public lecture. The last thing I'd like to do is, if I could, is to introduce Vanessa Zimmerman. Vanessa is recognised as a global and domestic corporate sustainability expert who has specialised, of course, in human rights. She worked for 5 years as legal advisor to the UN Special Representative on Business and Human Rights, Professor John Ruggie. And in the process of that, she was key to the team that were drafting the UN Guiding Principles on Business and Human Rights. She has worked with the Institute for Human Rights and Business, the UN Global Compact, and the Global Business Initiative on Human Rights. She has most recently been working on the implementation of the Human Rights Strategy at Rio Tinto. Vanessa has a Masters of Laws from Harvard University, and more importantly, a Bachelor of Laws and Bachelor of Arts from Monash University in Australia. In 2016, she was recognised as one of 100 of Australia's women of influence. Would you please welcome to the stage, Vanessa Zimmerman.
Up the stairs in my heels, so that was a victory. Just before I, with great pleasure, introduce Professor John Ruggie, it would be remiss of me not to say happy birthday to Kylie Porter. We're not going to sing, don't worry, but I have to say it. And happy birthday, Kylie. So it really is wonderful to see everyone here tonight. As many of you may know, this event sold out, I think, in a matter of hours or days. So it's really wonderful to have you all here. So it is my job to introduce Professor John Ruggie today, and I figured that the co-hosts and John himself would not be too happy if I simply stood up here and said he's the man. So I thought I'd better actually introduce you properly and then talk to people about your achievements. So Professor Ruggie is the Berthold Beitz Professor in Human Rights and International Affairs at the Harvard Kennedy School of Government. He served as the UN Special Representative for Business and Human Rights from 2005 to 2011. And his mandate was to propose measures to strengthen the human rights performance of the business sector around the world. The end result, of course, was the UN Guiding Principles on Business and Human Rights, or as we call them, the UNGPs, which were unanimously endorsed by the UN Human Rights Council in 2011. John is also a non-executive director in Arabesque Asset Management and chair of Shift. The invitation for tonight's event offered you the opportunity to hear from a true bastion of the global governance and corporate sustainability world. John, don't tell Harvard that I mentioned a competitor, but the Oxford Dictionary defines a bastion as an institution, place, or person strongly maintaining particular principles, attitudes, or activities. It also defines it, and bear with me as this is a little complicated, as a projecting part of a fortification built at an angle to the lines of a wall so as to allow defensive fire in several directions. And actually, the second definition, as much as the first, tells a little bit about how the UN Guiding Principles actually came into fruition. While today we may take the existence of the UNGPs, the now authoritative global standard for preventing and addressing business-related human rights harm, for granted, they were not easy to achieve. Navigating opposition from all sides, it would have been tempting for Professor Ruggie to water down the principles, or on the other side, opt for the perfect, the very likely enemy of the good. But throughout the process, Professor Ruggie remained steadfast in his commitment to principled pragmatism, closing the governance gaps that provide the permissive environment for business to harm human rights, while also recognising the need to build an understanding of human rights into corporate DNA. In my experience, the UN Guiding Principles on Business and Human Rights have achieved both of those aims. There remains much work to be done, and Professor Ruggie himself has said that the UNGPs are simply the end of the beginning. But they were an incredible gift to the corporate sustainability world that provided that concrete start. As someone lucky enough to be behind the scenes as we pushed for UN endorsement of the UNGPs, quite often to some unfriendly ears, the take-up of the UNGPs simply continues to wow me. I always get excited when I see my Google alerts pop up with an extra reference of how the UNGPs have been incorporated. From the latest Australian government's modern slavery guidance that incorporates the UNGPs, to the French duty of vigilance law that John will talk about today, to recent shareholder proposals calling for human rights due diligence in top ASX companies, and companies themselves referencing them in their human rights policies. Government, civil society, business partners, investors and businesses themselves are showing the value of the UNGPs, and we're only seeing expectations continue to grow in terms of how they are implemented in practice. Professor Ruggie's foresight to create a common language for all stakeholders, clarifying the duties and responsibilities of states and businesses around business respect for human rights, is clear to see and something to be celebrated. For me personally, it was a privilege to work on the UNGPs, and it's perhaps an even greater honour to now be working to implement them in practice. So, ladies and gentlemen, please join me in welcoming Professor Ruggie to the stage.
Thank you very much, Vanessa. I hope we have this on tape. I'd like to play it for my mother. She might believe you. But it's such a pleasure to be here, and particularly to have this event co-hosted by the UN Global Compact Network. I was present at the creation of the Global Compact, which shows you how far back I go. And also the Castan Center was a source of information and inspiration for all of us, and continues to be in the human rights field. And the business school at Monash is a world-renowned school, so I feel very privileged to be here. Thank you to all of you for coming out this evening. And I thought I'd take advantage of being in a distinguished university such as this to reflect in a more analytical vein on how we got from there to here and where we might go from here. And I hope you bear with me. It is not, your 10-minute TED talk, but I hope you find the reflections of interest, and I would be very interested to hear your reflections on my reflections. And so, without further ado, and I hope I push the right buttons, and something happens. I'm pushing the button, but nothing is happening. Okay. Which button? This one, right? Yeah. Oh, we didn't turn it on. There we go. So what I want to talk about is how the domain of business and human rights has evolved over the last couple of decades. From social norms that were the subject of contestation and dispute, to soft law, which is how some people describe the guiding principles, and into elements of hard law at the national level. And I think we all struggle with global problems, and what we don't have enough of is solutions and ideas about how to solve them. And one of the things that I was very struck with when we began the journey was that there was this common assumption among many people, whether in law schools or public policy schools, that if there is a global problem, what you need is a global treaty, and that'll solve the problem. And the fact of the matter is that that isn't always the case, and it isn't particularly the case when an issue is highly contested and controversial and complex. And so when I say we, going back to my days as Assistant Secretary General of the UN working for Kofi Annan, have tried to develop a different approach. One that is based on the sort of movement, if you will, across the domains of norms and soft law and hard law. And I think the theory of change, if there is one in this, is applicable to other global challenges, including issues such as climate change, for example, which we haven't been doing too well at the global level. So basically, as I say, my main aim is to look at the role of social norms in creating change and to see if there is a theory of change. By norm, I don't mean anything fancy, right? There was a norm not to smoke in restaurants before there was a law that banned smoking in restaurants. It was an expectation that developed among the relevant social actors. It has a quality of, there's a prescriptive element. No, this is not the appropriate thing to do in this particular venue or at this particular time. That's what a social norm is in essence. There is some probability of sanctioning by others. The sanctioning may be very weak. You may just get a dirty look from others in the restaurant because you're smoking. But it is a sanctioning. It tells you, if you're the smoker, that others don't appreciate what you're doing. And so norms are not causes. You know, a bullet through the heart causes death. A norm does not have that kind of causal effect. It sets expectations, it frames the way people think about a problem, the way they talk about a problem, and eventually, if things work, the way that they act. And so, let me go back. The first step to solving problems is to have what I call here situational awareness. You've got to understand the context that you're in. there is no such thing as a universal solution to anything. And if have a look at this figure that I still find so fascinating. In the decade from 1991 to 2001, 94% of all national regulations that were related to direct foreign investment encouraged foreign investment and deregulation and privatization and financialization and all the other aizations that went along with it. And this process was described by major leaders as a force of nature. Bill Clinton described globalization as a river that is cutting through the world, providing both power and disruption. If it's a force of nature, there isn't much we can do. And Tony Blair. I hear people saying we have to that we have to stop and debate globalization. You might as well debate whether autumn should follow summer. It's a force of nature. We can't do anything about it except to live with it. Bill Clinton and Blair, both at Davos, said we need to put a human face on the global economy. And Kofi Annan said, what about the rest of the bottle? Anyway, and what it resulted in is globalization and the proliferation of voluntary codes of conduct. Companies became literally global. Politics remained literally local. And the gap between the two is what has created so many challenges that we face today. Whether it is inequality, whether it is anti-globalization in the populist sense of building walls to keep out others. So, what do? Well, try something different. Our first step was the Global Compact. The Global Compact emerged from a speech that Kofi Annan gave in Davos in 1999. He says, hey guys, if we can't make globalization work for everybody, in the end it isn't going to work for anybody. The global economy needs stronger environmental pillars to survive and thrive. That was 1999. We're still hearing that today, and it's still a challenge, but we've moved. Now, the Global Compact has been vastly misunderstood by the academic community, particularly lawyers. If you look at the literature on the Global Compact, lawyers and some public policy people will say it's a watered-down regulatory instrument. It was never intended to be a regulatory instrument. It was intended to be a learning forum where companies could get together with union leaders and with civil society actors and actually develop a common understanding of issues to identify and help expand communities of practice. Even then, companies had intrapreneurs in them who cared about these issues, but they weren't linked to other intrapreneurs. So the Global Compact provided a platform for the intrapreneurs to become entrepreneurs for the cause. And the cause was to promote generally 10 principles drawn loosely from UN conventions in the area of human rights, labor standards, the environment, and anti-corruption. Secondly, and act globally, engage locally, there is only so much you can do at the global level. There's no global government. There's no Supreme Court. Right? There's no president of the world. So you can establish some norms through the UN process occasionally, but where it really counts is at the national level. And so national networks were established. Kylie, national networks, happy birthday. And interestingly enough, apart from the Scandinavian countries, the earliest were in some emerging market countries. Why? Well, we asked why. Because we want the major companies to know that we understand corporate responsibility, and therefore we can be good suppliers to them. Pretty smart. And so India actually was, outside of the Scandinavian countries, India was the first in an emerging market country, Brazil. China came along in 2011. I just 10 months ago visited with the Chinese national network. It's different from the Australian national network, and we don't have to go into details, but nevertheless, it's there, and it is promoting certain kinds of, particularly in the environment, responsible corporate conduct. Finally, it was a platform, or was intended to be a platform to reach out to different sectors of the business community. We launched the Principles for Responsible Investment in 2005, I believe it was. And that really is the origin of today's ESG investing, which now accounts for, what, 31% or so globally of assets under management. Not the PRI, but ESG investing as a whole. And so these were the objectives that we sought to accomplish with the Global Compact. Not to regulate anybody, but to build a social infrastructure to promote some of the goals that came out of the UN principles of human rights and environment and anti-corruption and so forth. In 2015, a consultancy did a survey of Global Compact members. This has not been much cited in the literature, but if you look at it, companies were asked to agree, or strongly or otherwise, that the Global Compact has made an important contribution, driving our implementation of sustainability policies. That's not regulatory, it's sort of educational. It's sharing knowledge and promoting common knowledge about how to do things. Step 2, the Millennium Development Goals. Why? Business has a role in creating shared value. It isn't simply do no harm, although do no harm is critical. It is the Hippocratic Oath, after all, for doctors. Do no harm before you do anything else. But business also has a significant role in creating shared value. The Millennium Development Goals were introduced in the year 2000. They expired in 2015, have been replaced, or succeeded, I should say, by the Sustainable Development Goals. Again, you see movement building on what was done before. And then step 3, thanks to Vanessa and other team members, we managed to pull off having unanimous approval from the UN Human Rights Council for the UN Guiding Principles as an authoritative global standard in this space. I want to say a few words about or reflections about how we sort of navigated through what was pretty difficult terrain. The first consultation that I convened was on the extractive sector in Geneva. And it was a food fight. NGOs, activists were throwing things at companies, companies were throwing things back at NGOs, and governments were sitting there like as though they were watching a tennis match. The ball goes back and forth, hey, nice return, yeah. Doing little about it. So, the first point, this sounds academic, plurality of governance system. But the first thing, if you're doing global policy, is to remember that there is no global government. And when it comes to issues relating to business and human rights and other areas of responsible corporate conduct, what you have is 3 different governance systems in place. One is the public governance system. You've got states, and they go to the UN, and they have meetings, and they adopt resolutions or treaties or whatever, and they may work or they may not work, they may not care, whatever the case is. That's the public governance system. We also have a private or corporate governance system. Companies themselves are governors of what goes on, for example, what goes on in our own company, or what goes on in extended supply chains. They have authority over that. That's authority is government. And then, of course, you have the civil governance system. That is the world of transnational and national NGOs who do research, campaigns, and the rest of it. And so we said from the beginning, no single actor is going to solve this problem. We have to find a way to work with all 3. Secondly, I'm not going to go into details here, it's useful if you can create a common knowledge base. In my first consultation with the extractive sector, it was all anecdotes. Rio did this and Shell did that. I'm sorry, Vanessa, that was before your time. It wouldn't happen now. Rio did this, Shell did that, and somebody would say, yeah, but my company has adopted this and we invested $13 million in social causes and we pay for school uniforms of kids. But there was no common knowledge base. How big is the problem? Where does it mostly reside? What sectors? Who does what? Anyway, the most important piece of research we did was an accident. I had a breakfast with the CEO of one of the world's major oil companies, who was giving me the sort of the business case for doing things, but also the business case for not doing things. And the balance was not quite right. So I asked, I've read in the paper that your people get kidnapped, your pipelines get blown up, there are oil spills all over the place. The length of time it takes you to get permits has increased vastly. Do you know what that costs you? No, not really. Why not? Well, because we roll it into local operating costs. So I said, how about trying to measure this? Would you be willing to do that? And he said, yeah, sure. And so they hired a consulting firm, turned over 2 years worth of data, did the analysis, and came back, and we had another meeting. So what's the answer? Well, there was a low, a medium, and a high of what the cost was. The medium was $6.5 billion over a 2-year period, when the profit was $20 million per annum. And I said, I live on an academic salary. I don't understand. Is this a big number? And yeah, even for us, that's a big number. And so what did they do? They changed their accounting system. And now the discussions internally between people who do the kind of work that Vanessa did for Rio have greater credibility and more clout because they actually have some numbers to point to. I just don't want to belabor this too much. Process legitimacy is critical. We conducted 50 international consultations. So nobody could say, you didn't hear our story, you didn't come to my country, or whatever the case may be. Engage new communities of practice. The debate had been at loggerheads. And we weren't going to change that unless new actors were drawn in. And Vanessa had this wonderful idea. What about corporate lawyers? I said, are you nuts? Corporate lawyers? They're the bad guys. She said, no. They're very influential. And so, actually, the first ones we met were out. And they weren't bad guys. They were good guys. But by the time we were done, Vanessa had organized, 22 or 23 law firms around the world to conduct pro bono research for us. And to start talking to their clients about these issues. It was like night and day. All of a sudden, we had advocates who could walk into the CEO's office and say, wait, let's look at this again. Road testing, we did experiments. We did on-the-ground experiments whether the recommendations would actually work. And the bottom, the last point was a laser focus on how to do things rather than argue about doctrine. I don't know how many times I said, I will not argue about universal values with the Chinese. It's not going to get me anywhere. I will argue with the Chinese that their overseas companies in Latin America or elsewhere are not doing a good enough job at dealing with community relations and that sort of thing. And here is how you deal with them. Give them the tools. But I'm not going to argue doctrine. I'm not going to argue whether values are universal or not. That belongs in an ethics course, in a philosophy department. This is global policy, and it doesn't work. So what we did was I'm sorry, this is another academic expression, multi-perspectival framing. I can barely pronounce it. But what we did was, we said, wait a minute, we got 3 governance systems, and they're quite different in this space. They have different roles, and they have different obligations. Now, so when the guiding principles addressed states, it was in the language of legal obligations because states have adopted these treaties. Right? You adopted this treaty. Now, you may not yet fully understand what it means for business and human rights. Let me tell you what it means. The guiding principles will guide you as to their meaning. But it's an obligation. It's a legal obligation. For business, okay, you've got to comply with the law, but beyond complying with the law, we focused extensively on the risk of involvement in human rights abuses. Companies generally do not have obligations under international law, but they sure as hell have risks for violating expectations, and those need to be effectively managed. For affected individuals and communities, the guiding principles provide a basis for furthering the right to remedy. And what the guiding principles did was to weave them together into a single normative platform. 31 principles: protect, respect, and remedy. Now, you have to be a little more explicit about what the problem is and how you deal with the problem. So let me focus on the business side. Pillar 2. Somebody just started an advisory firm by the name of Pillar 2. Nice party. Thank you, Vanessa. So a company can cause a negative impact. We have something in the States, a set of shops called the Pottery Barn. And they have a sign on the door. You break it, you own it. That's cause. Okay? You hire slave labor, that's cause. And nobody else is involved, it's you. Companies can contribute to negative impacts, even though they don't cause them. When, I think it was the iPhone 6, I can't remember for sure, Jobs, the CEO of Apple, Steve Jobs, got a sample of the phone about 6 weeks before shipment was due from Foxconn. They wanted it out at Christmas time. Jobs looked at the phone and didn't like the screen. And he said they all have to be redone. Did he raise the payment? No. Did he extend the time frame? No. What happened? They were delivered. But in the meantime, you remember the news stories of people jumping off the roof at Foxconn because of the fact that they were so badly overworked and frustrated? That's a major contribution to a human rights abuse. Apple is still one of the most valuable companies in the world. They took a brief hit, and they have changed their policies and practices. And so, of course, is Foxconn. Thirdly, a company can be linked to negative impacts, directly linked to them. Rana Plaza, 1,200 people died when the building collapsed. There were companies who were sourcing at the time from Rana Plaza, and they, of course, many of them felt some sense of responsibility for contributing funds and to update facilities and do inspections and so on and so forth. But some who had previously sourced, but were not sourcing at the time, also contributed. Why? Because they felt that they were linked to the problem. They had no obligation to remedy because they weren't sourcing at the time. But the guiding principle suggests that even in that circumstance, that there ought to be some acknowledgement of the problem by the company involved. Now, how do you know what your involvement is? Well, we invented the notion of human rights due diligence for companies and spelled out essentially what the elements of it are. And it's very simple. You basically identify impacts on people, you evaluate them for severity, you prioritize them for attention, you prevent, you mitigate, you contribute to remedy. Now, what kind of remedy and what do you have to do depends on the nature of your involvement. If you've caused, you break it, you own it, you fix it. If you have contributed, you obviously you prevent or mitigate, stop your contribution and try to prevent and mitigate what the effects still are, and use your leverage with the other responsible party to the extent that you can. If it's just a linkage, use your leverage, try to prevent or mitigate the impact, but you do not have an obligation, a remedial obligation. All right, next chapter. Guiding principles adopted, all the rest of it. Typically, when there is a mandate such as ours, or even when there is a treaty adopted, it is sort of put into a silo. And it has a particular implementation mechanism. And it may work, and it may not work. We did our best from year 4 on to start working with other parties that had a role. The International Finance Corporation has a role in business and human rights because it co-finances investments and provides investment insurance and other such things. So start talking with them. The European Union, the Global Compact, of course, was very eager to participate. Anyway, get it out of the silo and have others also participate in the implementation. This is true not only globally, it's true anywhere. You can't do everything yourself. And the sooner you bring, if you want people to be there with you at the landing, they got to be there with you at the takeoff. They have to have a sense of ownership in the aim of the project, and that was one of the strategies, if you will, or that we employed. And then national action plans. Countries, governments unanimously endorsed the guiding principles. Okay, then do something. Thank you for the endorsement. I really appreciate it. And even more so because it was the first time that governments had ever endorsed a normative text that governments did not negotiate themselves. We wrote it and presented it to them, and they said, yeah, okay. All right, now thank you, do something. One of the things that they have done, or are doing, is to develop national action plans. The content of most national action plans is great, I admit. Most of them tell you much more about what they've done in the past than what they're intending to do in the future. But, two things. One, it is the first time, to my knowledge, that governments as a whole are discussing business and human rights, not a sub-department of the foreign ministry or whatever other ministry. Governments as a whole. The German National Action Plan fight among the various ministries was fascinating because 11 ministries participated. The finance ministry threw out key elements of the National Action Plan. The other 10 then beat up on the finance ministry. And one of the fascinating provisions in that is this. At the time, this was 2 years ago, if 50% of German companies with more than 500 employees don't have adequate human rights due diligence systems in place, the government will help them. And legislation is being discussed as we speak in Berlin about how the government is going to help them. The Chinese have been interesting. They actually put out guidelines for their overseas mining operations. The problem is that they work best, they're most effective in places where there is a semblance of democratic government or where there's an active civil society. Doesn't work so well in places like Myanmar. Business, leading businesses were on board. Unilever was the first company ever anywhere to issue a freestanding human rights report. It was invoked by labor unions. This is the Immokalee workers who were campaigning for a penny increase for tomatoes they were picking in Florida that were used by McDonald's. And as they started their campaign, the guiding principles came out. I had nothing to do with this, by the way. They discovered that there was such a thing. And so they used the guiding principles as a negotiating tool with the farm owners and, of course, with McDonald's itself. Intermediary institutions got involved. The International Bar Association put out a guide on what the business and human rights principles mean for corporate lawyers, for business lawyers. And some, I know of several major law firms, global law firms, who actually have now adopted internal principles for themselves, reinforced by the oddest characters in the world. Corrupt FIFA. And it was precisely because of the corruption that I got a phone call. Would you please advise us on human rights? So I went off to Zurich. I met with the then president of FIFA. And he said, you know, we're dealing with a corruption problem over here, but we also have a human rights problem, and some of the sponsors are beating us up. So help us out. Sure, I'll be happy to. And they were so vulnerable that they actually accepted what I recommended. Now, the guiding principles are part of bidding requirements for future World Cups. And it was hilarious. They were bidding for 2026, and Morocco was competing to host the World Cup. And the king kept issuing edicts on human rights policy. I have no idea how that would have ended up. They didn't win the bid. The bid went to Canada, the US, and Mexico, a joint proposal. The Players Union, Fifth Pro, similarly has endorsed. And guess what? Well, if FIFA is doing this, why isn't the International Olympic Committee doing this? And what has the International Olympic Committee done? They've just signed up the outgoing High Commissioner for Human Rights, saying, to become an advisor on developing a human rights policy for the IOC. Now, my current preoccupation is with ESG investing, for the very simple reason that we have known since we were tiny that money talks. And if we can move markets through ESG investing, we will move the needle. And what is interesting, although it is not known in much of the ESG community, is that virtually every component of the S has to do with human rights. And there are now international standards for both content and process. And so I'm on a mission to tell investors that the S is all about human rights. Data providers particularly don't yet understand this. Analysts don't understand it. But ESG keeps increasing. It's now a quarter of all assets under management globally. And finally, elements are now incorporated into national hard law. Anti-slavery legislation has basically incorporated and sometimes cited the human rights due diligence requirements spelled out in the guiding principles. I was in Ottawa just a couple of weeks ago. I was invited to participate in the appointment of an ombudsperson to oversee the foreign operations of Canadian companies in the mining industry. Mandatory due diligence, the French law is in place, although we don't yet know how it's working. Mandatory due diligence is almost inevitable at national levels and in the European community. Now, one final point, and this is important for going forward. When I submitted the guiding principles, I also submitted a standalone proposal that governments consider establishing a working group to develop essentially a focused international treaty to look at the most glaring protection gaps that remain. And I felt that an important focus for that would be on sort of the worst forms of human rights abuses by companies. And I called this a sort of a precision instrument approach, focused on a specific gap where you might get enough agreement to get a meaningful instrument in place. Unfortunately, I want to put this in a diplomatic way, but some of the advocacy community and some of the human rights lawyers came out in opposition to this, saying it didn't go far enough. So once that was said, there was no government and no business who was going to say anything. And so it didn't happen. What is going on now in Geneva is yet another attempt to put the entire sphere of business and human rights into a single treaty instrument. And that, of course, isn't going to go anywhere, and it hasn't learned the lessons that I think are out there. So just some summary observations. First, obviously, there is no silver bullet solution to these problems, but it is possible, it has been possible to establish a sort of a dynamic process where things build on each other. And reinforce each other. The voluntary versus mandatory dichotomy is pernicious. I've never seen a society on the face of the planet where all rules are voluntary, and I've never seen one where everything is mandatory. We have to think in terms of smart mixes of policies and laws and practices and incentives and the like. It was very important to focus on how-to provisions, not doctrinal debates. It was very important to involve new communities of practice. Working through other networks had cascading effects, many of which we could never anticipate. And we have worked, Ness has worked with the Australian government, I've worked with the Canadian government and others, and the European Union, to incorporate various how-to provisions into national or regional part law. And, as I say, comprehensive international treaty initiatives are unlikely to succeed. They haven't succeeded in the climate change area. The climate change area has gone from a binding instrument to what we have now in Paris, which is sort of a naming and shaming process. Wouldn't it have been better to start with a naming and shaming process and work your way up the food chain They did it exactly the reverse way. And it just wasn't, it didn't have legs, it didn't have roots. And therefore, climate change became highly politicized and the climate change policy, and we've made very little progress in this. So my final point is, if you want international law in very complex, very controversial, and contested areas, focus on precision instruments, not comprehensive measures. And I think that's it. Thank you so much.
Thank you, John, that was amazing.
Can I give you a hard time?
A little bit, so that's okay. I was expecting it.
I just pay you back.
I'm going to be deeply unpopular because we probably only have time for 3 questions. I know. Just so we can finish up on time. So do we have some roving mics? We do. Okay, can I have a brave person wanting to ask the first question? And a question rather than a comment is great. Leora, and then we'll go, we've got over here. Yep, Kerry. And then do we have one more person? Someone right at the... Oh, Mario, and then maybe just the person back. So 4 I lied. 4 and not 3. Okay, so Leora first.
Thanks. Leora Black from Deloitte. I have actually 2 questions, but I don't mind micro answers to both of them. The first is, in your view, what impact will the Australian modern slavery legislation have on the actual problem of modern slavery? And the second completely disconnected question is with your discussion on social norms to soft law, how did that happen? What were the social norms? How did they morph into soft law? And a micro answer is fine. I know that Vanessa will kill me if I tie you up.
Do you want to answer them one at a time?
Whatever you...
I think we'll just we'll take all the questions at once and then let John answer just in the interest of time. So maybe Karen next, depending on where the microphone... You got the microphone, Karen? Just down here to Karen, and then... Yeah.
Hi John, thank you for that. And I'm interested in what you say about the difficulty at an international level of achieving these kind of very broad-based measures. But I'm interested in your reflections on where that's occurred at a national level, such as in the French law, which is much more comprehensive and attempts to impose much broader obligations than something like our Modern Slavery Act. Whether you feel that that is actually a better way to go than these very, very specific measures that are being taken in much more specific fields like modern slavery, which don't address broader human rights problems that may occur in supply chains.
You know what, given the jet lag, I'm going to let you answer those 2 first, so you don't have to remember 4 questions. So start with these 2, and then we'll go to the other 2.
Okay, thank you. So the Modern Slavery Acts, there are several in place. My sense is that it will have an effect of raising the profile of human rights issues more generally. At a time when the Alien Tort Statute in the US was still in effect before the Supreme Court threw it out in terms of application to business. The corporate responsibility agenda benefited enormously. Not because companies were necessarily going to be charged under the Alien Tort Statute, but because they had to figure out whether they could be charged for anything that in their supply chain was going on. And my sense is that the Modern Slavery Act will have exactly the same kind of consequence. It's going to raise the visibility of the issue, and you don't know ex ante about whether you have forced labor in your supply chain. You've got to research it, and you've got to find out whether or not you do. And in the process, as I say, the visibility, the awareness of the issue inside companies is going to increase. That was on the modern slavery. What was the...
And the French due diligence.
Oh, the French due diligence law. Yeah. Yes. I mean, we can't replicate national judicial systems at the international level. Why not use the mechanisms that exist, that have the capacity to enforce? So you develop norms globally, you have specific targeted treaties to close specific gaps. But the more robust and the more comprehensive regulations have incentives or disincentives have to be the national level, because that's where the capacity remains. The regional level, because in the EU, because you have enough of an infrastructure there to make it work. But throwing it into sort of the global domain and hoping that good things will happen is very problematic.
Two more, so Mario, and then just, oh, the microphone up there. We'll take this question first and then thanks. Thanks.
Yeah, thank you so much. My name's Claire Beitz. I'm here from Griffith University in Brisbane, and it's been such a joy to listen to you after reading your works for a number of years. My question was around blue washing. We've got greenwashing, we've got blue washing around the Global Compact, and seeing that statistic up there that 9,500 have signed up, but 4,000 have been effectively expulsed. Has there been any work done on the impact of people who have been, anyway, asked to leave the Global Compact from blue washing?
You mean apart from being thrown out?
Yes.
Or what the consequences of being thrown out?
Yeah.
I'm not aware of any research on that.
No, okay. I was just wondering whether or not they improved their action after realising their
I don't know.
Thank you.
Sorry.
And maybe just building on that for 1 second before we get to Mario, which is, how do you know if a company is not actually walking the talk on human rights? How do you know that they're blue washing?
Well, it's a tough question. What actually happens on the ground is part of the evidence. What the company internally, the systems that it puts in place are part of the evidence. There was one mining company, it was not real, that put out its first human rights report and says, don't judge us by the mistakes we make, but by how quickly we fix them.
I wouldn't be surprised if we see a few other statements like that.
Thank you. Mario Santos from Amnesty International. Thank you for a great description of how you got to how we got to where we are, in particular for that final slide with the summary of learnings, which is very interesting. And I'm really sorry to finish with this question, but I was wondering whether, with the benefit of hindsight, there is anything that you might have done differently.
Oh, God. Sure, but what would we have done differently? I would have made you work harder. Mario, to be honest with you, much of the time, we had certain basic understanding of what we wanted to achieve and how we wanted to achieve it. But in retrospect, I can sort of construct a theory of change out of it, but as we were going along, we were making things up as we were going along. It was learning. It was learning by doing. I'm sure there are things we could have done differently and better. I shouldn't have had as many arguments with Amnesty as I did. But life is what it is.
Thank you so much. So thank you. If you all join me in thanking John. Please welcome Gina, who's going to do a vote of thanks. Thank you.
Good evening. It falls to me to close the proceeding. I want to first introduce myself. John, I am a professor in the Faculty of Law at Monash University and an associate with the Castan Center. I want to thank the Global Compact Network in Australia for having invited us to co-host this along with Monash business school. And especially in the context where we've just seen the Modern Slavery Act pass, and we're seeing very much the landscape in this country in the midst of transformation. So in that context, at Castan, we've often worked very hard in various areas looking at issues of human rights. And for us to have, as you mentioned, to be a bit of a resource center for your work has been really instrumental in us achieving the types of things we want to achieve. At the moment, the landscape in Australia is fruitful. There's lots of possibilities. And in that context, it's clear to me, and I think to all of us here, and the numbers speak for themselves, it's been really great having you come and speak to us and to enlighten us a bit on the way forward, the possibilities for us. So will you join me in thanking Professor